Hello, I'm Michelle Radham, Head of Disputes Knowledge at Osborne Clarke. I'm joined today by Rob Guthrie, who's a partner in our Intellectual Property Disputes team, and Richard May, who's an Associate Director in the same team. And today we're discussing the implications of Brexit on IP rights. Basically, the starting position is that we're in a transition period at the moment and nothing is going to change until the end of this year. But Rob, at the end of the year, how will IP protection change in the UK?
Well, perhaps, Michelle, the first thing to say is, although today we're obviously going to discuss where there are going to be changes and issues that IP owners need to think about, for a lot of things, there won't be any change. The substantive law is going to remain the same. The levels of protection are generally going to remain the same. But there are some areas and issues that IP owners need to think about. And Richard, probably chief among those is what happens to EU trademarks and community designs.
Yep, that's right. So for trademarks and designs, essentially the impact will come at the end of the transition period. And what that impact will be depends on whether you have a registered design or trademark or whether that is still a pending application. Because what the UK is doing is for registrations for both designs and trademarks, they will clone the registration at the end of the transition period. And that's a relatively straightforward, pain-free process for rights holders because that's going to be an automatic process without any official fees. The position is slightly different for applications. If you have a registered an EU application, whether it be a design or a trademark, what the UK is going to do is allow rights holders a 9-month grace period to effectively refile that EU right in the UK. So the ultimate goal is to ensure that there is no loss of rights for rights holders.
And what else is changing, Rob?
Well, one area where there might be some loss of protection is on the issue about whether the EU and the UK are going to still grant each other's nationals and businesses the same reciprocal protection for their own nationals and businesses. Now, this doesn't impact perhaps the most sort of economically important IP rights, such as patents and trademarks and copyright, but it potentially does have some impact for things like database rights and unregistered designs. Now, these issues might get resolved as part of a future trade deal, but if those IP rights are important for your business, then this is an area that you need to look into and consider whether there might be an impact. Also, sort of looking forward in the sort of medium to long term, we probably see some divergence between the IP position in the EU and the UK. Two areas just to flag: the Digital Copyright Directive adopted by the EU, but the UK government says it's not going to implement that, so that's an area of potential divergence. And also the Unified Patent Court that we're expecting to come online in the next couple of years, and there's certainly some question marks about whether the UK can still be part of that institution in a post-Brexit world.
And finally, what can IP owners be doing now to protect themselves against Brexit?
Well, certainly one thing that I think they should be doing is having a look at their IP licenses and other agreements with territory provisions in them, particularly where the territory is stated to be the EU. How will Brexit impact that? And worth flagging that there are provisions in the UK Brexit legislation which might impact the interpretation of those provisions. So need to be aware of those.
Yeah, and from a trademarks point of view, it's certainly worth considering what is going to be ongoing in terms of matters come the end of the year, because if you can expedite those matters through to completion, then it's going to be a cost saving. For example, a trademark application, if it's pending, then if you can push that through, then you can avoid having to refile after the transition period expires. Also, in respect to trademarks, it's worth considering whether you have any security interests or licenses registered against those EU marks. They won't move across automatically, so it's worth considering whether you do need to refile them in the UK. And in terms of customs registrations, again, if you have customs registrations, certainly worth considering whether you need to refile them in the UK or EU, depending on the type of registration you have in place at the moment.
Thank you. And if you're interested in finding out any more about Brexit and the impact on IP rights, the article is available on the Osborne Clarke Insights page.